Welcome to another episode of The Intersection. I'm Chanae Wood, partner at Weiss Serota, Helfman, Bierman. Today we're discussing what may be one of the most consequential local government issues facing Florida in years. The legislators' proposed constitutional amendment on property tax reform, which will appear on the ballot on November 3rd, 2026. While much of the public conversation has been focused on tax relief to homeowners, local governments are evaluating the much broader implications on the potential reduction of services, loss of revenues, and increases in other revenues. For cities and counties across Florida, the stakes are significant because property taxes fund many of the services residents rely on every day. Joining me is partner Jamie Cole to discuss what the proposal would do, where it stands today, and some of the legal questions it raises. So Jamie, thank you so much for joining us today. I want to jump right into this because this is a very meaty, hearty topic that we're going to go through today. Let's start with the basics. What exactly did the legislator approve, and what happens next?
Thank you, Chanae. Nice to be here. The legislature approved a joint resolution, which means that the House and the Senate each passed a resolution that was approved by more than 60% of each of the houses. The measure puts on the November 3rd ballot a question asking voters whether or not the Constitution should be amended. The amendment would increase the homestead exemption to $250,000. It's currently at $50,000. It would also make some other minor changes, but that's really the bulk of what is being proposed to change. If you look back historically, originally the homestead exemption was $5,000, then it went to $10,000, and eventually went to $25,000, and then eventually went to $50,000. This would put it all the way up to $250,000 in 2028, and it would be adjusted for inflation after that point.
Okay, so many people are really looking at this, and the buzzwords that you hear in the press is that this is some form of property tax relief, right? But when you look at this proposal a little closer, it doesn't seem to be just that. Can you share why local officials should care about this proposal in the first place? Why does this matter?
Well, what it does is it lowers the total tax base upon which taxes are levied. So when you get a tax bill, there's two aspects. One is how much is your house being worth that you're applying the tax to, and the second is the millage rate, which is the tax rate. What this will do for homesteaded properties only, it will add this additional $250,000 homestead exemption. So if your house is worth $250,000 and you have a $250,000 exemption, you would pay no property taxes. But if your house was worth $1 million, you'd pay tax on the $750,000 of the assessed value. The effect will be to substantially reduce the total amount of property taxes that each county and each city and each other special district will get. That will force them to do really one of two things. They can either cut the amount they spend, which will mean cutting services, like having less police, less fire, less parks, or they can raise the money some other way. They can raise the money the other way by increasing the tax rate. So if the millage rate is currently, say, 2 mills or 3 mills, which is $2 or $3 per $1,000 of value, they could increase it to 4 or 5 or 6 on everyone else. So all the people that don't get the benefit could see higher taxes. So businesses, renters, if you rent an apartment, your landlord will have to pay more taxes. And unfortunately, as I think you and I know, most of the time when a landlord pays more taxes, it means the tenants are paying more taxes because they just pass it through. They could increase fees. If you go to a park, you may pay more to go into a park. So there's lots of ways to raise other revenues. So cities are kind of in a Hobson choice. They can either cut services or raise other fees or raise the millage rate, and they'll probably do some combination of both.
And so as we both know, and many folks do too, when it comes down to property taxes, it's a huge source of revenue for local governments. So it sounds like this might be ripe for litigation. And oftentimes when I think of Jamie Cole, I think of litigation. And so before we go down that path though, what I found to be interesting about this particular proposal as well, or this particular scenario, is that this isn't the first time in Florida that we've had an issue with property tax reform and ballot challenges. In fact, you have participated in a lawsuit in the past. So could you just share a little bit about what that looked like for you all those years ago?
Sure. Ironically, it's almost exactly 20 years ago, on June 14th, 2007. So almost exactly 20 years ago. There was a special session. They had a joint resolution. They put something on the ballot, and what they put on the ballot was what they called a super tax exemption, which was actually based on percentages, but it equated to $195,000. This time it's $250,000. So with inflation, not that much different. So they put that on the ballot, and it would have replaced Save Our Homes. And Save Our Homes is the limitation on increases in assessed value of 3% each year. In the ballot, they said that it was going to preserve Save Our Homes. In actuality, it was going to phase out Save Our Homes. The then mayor of Weston, Eric Hirsch, was very upset about it, and he wanted to challenge it. I represented him. I brought the lawsuit. We convinced a circuit court judge, Judge Francis, up in Tallahassee, that the language was misleading. He agreed. He declared it was misleading. He threw it off the ballot. And after that, the legislature decided not to pursue it. They had initially appealed. They dropped the appeal, and they went forward with instead a different proposal that actually increased the homestead from 25 to 50 and created the portability. So the end result was something that was not quite as drastic as what was originally proposed. Now, if you remember historically, in 2008, there was a terrible recession and property values crashed. Cities' taxable values actually went way down. Had that super tax exemption been put into place and coupled with the economic recession, cities would have been devastated financially.
Right. So it's clear that this is not your first rodeo, right? It might even feel like a little bit of deja vu for you, to be honest. Since 2007, has the legal standard as it relates to these ballot challenges, have it really changed since then?
Not really. I mean, it's always been the concept in Florida and really everywhere that your Constitution is the bedrock of your government. It is only changed by a vote of the people. And in fact, in Florida, you now need 60% approval to approve a constitutional amendment. So it's a major thing to change the Constitution. The right of people to vote, however, is absolutely meaningless if what is placed on the ballot doesn't tell them the truth, if it misleads them. So the standard for a ballot question is that it's supposed to be neutral. It's supposed to give the chief purpose. It's supposed to tell them what they need to know. What it can't do is it can't be advocacy. It can't be misleading. It can't give incorrect information. It can't hide the ball. And that standard's been around in Florida. 20 years ago, it's been around in Florida. 40 years ago, it's probably around for 60 years ago. That's been very well settled for a long time in the state of Florida.
That's really good to know because as we look at this current proposal, let's get into it, right? Because if you said it's not supposed to be misleading, it's not supposed to advocate, then tell us and the listeners, as you look at this proposal, what concerns do you have regarding the ballot title and the summary?
There's really 5 major problems with it. And there's only really 5 sections of the ballot question, so it's pretty much the entire ballot question has problems. The biggest problem, or the initial problem, is that it does advocate. It is not a neutral statement. In fact, when you read it, it reads like a political flyer or a mailer that you get in the mail. The title of this should be something like Increasing Homestead Exemption. That's really what this is doing. Instead, the title is Save Our Homes from Excessive Property Taxes. It's a clear political slogan that's being used for the title when the title is not supposed to be a slogan. It's just supposed to be telling people what the issue is generally described as. And then the summary goes on after the title, and it says, this amendment benefits Floridians, Florida taxpayers by, and it lists a whole bunch of things. So basically what this is first it's a political slogan, and then it's a list of benefits of the measure. Now, if you're trying to be neutral and fair, you don't just give the benefits, you give the positives and the negatives. This only gives the benefits. And unfortunately, when it gives the benefits, it doesn't even do so in a fairly and accurate way. So the second problem is the next section, which says that it's exempting homestead properties from taxation, which is what it does, for the first $250,000. It doesn't tell voters that in the first year in 2027, it's $150,000. It's not $250,000. And it doesn't tell voters that after that first year at $250,000, it goes up. So if it goes up 4% from 2028 to 29, it goes from $250,000 to $260,000. 10 years later, you're at $400,000. I mean, it will just go much higher. So it's not just $250,000. So that's misleading. But that same section also says that, and this is a quote, it requires through general law a schedule for full elimination. So when you hear that, you would think, well, all right, so it's going to be $250,000, and then the legislature it requires the schedule for full elimination. So you're going to eliminate all non-school homesteaded property taxes. But that's not what it actually does. What it actually does is there's going to be a schedule, but the schedule is to set up procedures for counties and cities to decide whether they want to have a higher exemption above the $250,000. And it doesn't necessarily go to the full elimination. Rather, it says up to the full amount. So legislature could decide that it's not going to be the full amount, and the cities and county commissions may decide not to do it. Now, the third problem with the ballot is the next section. And what it says is, quote, ensuring funding for core services, end quote. So when you hear ensuring funding for core services, and then it lists public safety and education and infrastructure and natural resources. The problem is that it does not ensure funding for those core services. In fact, there's nothing at all in this ballot, in the proposal, that ensures funding. It does the opposite. It takes away resources. It takes away money from counties and cities and hospital districts and all these other districts, and it does not replace that money. So how does that ensure funding for core services? It just simply doesn't. It's just a totally inaccurate statement. Now, it may have been that in initial draft of the proposal, there was limitations and money had to be spent just on core services, but that was taken out because it was broadened that the money, ad valorem taxes, can now be used for everything. So that statement is just simply wrong. Then it says that it's protecting small businesses. When you go through the actual proposal, there's not one time where small businesses are even mentioned. There's nothing in this proposal that protects small businesses. Now, there is a provision that will say for non-homesteaded property assessed values can't go up by more than 5%, whereas it's currently 10%. And that would include small businesses. But that doesn't protect small businesses. It doesn't have anything to do with small businesses. That's all non-homesteaded property. But beyond that, what this really does to small businesses is that if they own property, if a small business owns a piece of property, their tax rate will most certainly go up. And if their tax rate goes up, their taxes are going to go up. That is not protecting small businesses. That's hurting small businesses. And then the final issue deals with language that says in the ballot question, ensuring fairness for Florida residents. When you hear that, you would think, well, this is going to be fair. It's going to treat all residents the same. But that's not at all what it does. Because there are Florida residents who own their own homes, and this is going to benefit them, their homesteaded property. But there's a lot of Florida residents who don't own homes, who rent.
Right.
Someone who rents property is going to be injured by this, because what's going to happen is their landlord is going to pass on those higher property taxes caused by the higher millage rate. In addition, this will create two classes of Florida residents. Florida residents who were here and had residency on December 31, 2026 get this benefit. But anyone that buys a house who was not a resident on December 31, 2026 will not get the benefit for 5 years. So for 5 years, they will only get a $50,000 exemption. And then after the 5 years, they get the $250,000 plus inflation. Creating two different systems and discriminating against one category of Florida residents is not ensuring fairness. So overall, this ballot question is biased, it's misleading, and it's inaccurate. It's the exact type of problems we had back in 2007 on steroids, because it's far worse than the problem back then. And back then it was very bad as well.
Right, and you took the words out of my mouth. What you just described it sounds far worse than the 2007 case, and we know what happened in that circumstance. What you just broke down is probably just the few that we are going through on this episode, and it's probably plenty more that you can identify. With that being said, why do you believe a challenge is necessary in this case?
This is a very important issue. This issue is going to affect people's in the pocketbook for decades to come. When people go to vote, they need to be treated fairly. They need to be told what they're voting for. Now, obviously, there's going to be a big campaign. There will be people campaigning for it. There will be people campaigning against it. And there will be some voters will listen very carefully to both sides, but then there's some voters who won't. There's some voters who really won't know anything until they actually get into the ballot box. Right. And when they go into the ballot box or they take their vote by mail at home, they're just going to read what the ballot question is. It's really rigging the system to go and take a ballot question and do it in such a biased and misleading way. It really just tricks the voters. And that is anti-democratic, and that's just not what we should do. So what the purpose of a challenge would be to not stop tax reform. Eventually, the voters need to decide whether or not we should do this or not. But when they decide, they need it to be presented in a fair way. So a court needs to declare that it's invalid and then determine what happens next, whether the Attorney General should fix the language if that's constitutional, whether or not it should be fixed by the legislature. Maybe they can have a special session. If there's not time because they waited so long to do this, it may have to wait and be voted on the following year. By the way, there's every 20 years in Florida, there's a group. There's a taxation and budget committee that meets every 20 years to review taxes and budget issues and propose things for the ballot that things should be changed. Ironically, that group is going to start meeting on January 1, right after this would take effect. There's no reason that they couldn't consider this as part of their review. But nevertheless, the main thing we would be trying to accomplish through any type of a lawsuit would be what we were trying to accomplish back in 2007. Make sure that we treat the voters fairly. Make sure we give them an accurate ballot language that's neutral, that gives them all the information, and they can make the decision. Because there are good arguments for both sides here. Right. And the voters would just need to decide. But to rig the system one way or the other is just not right.
Yeah, they need to decide fairly and without being misled to one conclusion over the other. Before we wrap up, a few more questions though. I want to just make sure that anyone listening understands who has standing in a lawsuit like this. Who would be the plaintiff in this situation?
You know, what's interesting is standing is a doctrine that basically says that you can't just go to court unless you actually have an interest in something. This is the kind of thing that almost everyone has an interest in. Every voter, every taxpayer has an interest in having a fair ballot question. So any voter, any taxpayer, any groups that represent those, they would all have standing to bring this type of challenge.
That's good to know. So if there were an elected official, a local government leader, or even a community member, as we've mentioned, they want to learn more about joining or becoming involved in a potential challenge, what should they do?
Well, they can contact us, and we'll give information as to how to contact us. We have been contacted, in the last couple of days, we've been contacted by so many elected officials and just people in the community that are so concerned about it. And they've asked us, kind of begged us to do something. So we've been analyzing this. We've been really trying to determine whether or not there is a basis for challenging the ballot language. And we really do think that there is, but we don't take this lightly. We've actually spent a lot of time looking at the ballot language, because if we didn't think it was defective, we wouldn't move forward on something like this. But we've got so many people that have been urging us to move forward. We do plan to do so.
Absolutely. And I know even internally at the firm, we've had several calls and meetings, because it really is something that is important to us as a firm to get ahead of, and to be able to not only provide these services, but offer this information as well for individuals who just don't know. And so, Jamie, thank you so much for joining us today. I think this was a very informative conversation. We got into not only the amendment itself, the proposal itself, but also the legal concerns around it, which sometimes I think can be overlooked. And so I think this was a phenomenal conversation, and I'm sure you will continue it. And so thank you again for joining us here on The Intersection.
Thank you, Chanae.
Jamie, thank you so much. That provides important context not only about the proposed amendment itself, but also about the legal concerns that have been raised regarding the ballot question. Now, assuming this proposal continues through the constitutional amendment process, local governments and elected officials will need to navigate a number of practical and legal considerations. To help us discuss those issues, we're joined with my partner, Susan Trevarthen. Susan, welcome to The Intersection. So Susan, tell us, what should local governments and elected officials be doing right now as they evaluate this proposal?
Well, what they should be doing is figuring out exactly what it means for their community. So first of all, the Florida League of Cities has published general data that covers the impacts on all of the cities in the state of Florida. So you can start with that. And then most of our city managers and finance directors have, throughout this year of discussion about potential tax reform, started to do more detailed analyses of how their individual city is affected. First, we start with the fact that it attacks ad valorem revenues specifically. And so starting with that, we need to isolate out that portion of the revenue portion of the budget from all the other revenues that are unaffected. So things like grants or special taxing districts, special assessments, user and impact fees, other kinds of things like that are not going to be affected by this tax reform.
Right.
And then within that ad valorem revenue, they have to drill down to the homesteaded revenue. That's really the target of the changes that are happening here. And the impact of that really varies widely between communities, because it depends on how much value you have in your tax base for residential property that is homesteaded versus residential property that may be for renters, or maybe it's for seasonal residents, so they're not able to have a homestead exemption. Another thing that cities have already done, and if they have not, they should consider starting to do right now, is to prepare for a brand new law that passed in this session during the regular session that requires all cities next year to do an analysis of how they might cut 10% from their budgets. And that same kind of methodology could be used with an eye towards the impact of tax reform. So what if the analysis showed that the impact of tax reform in your community was 30%? Maybe you would do the statutory 10% and you would do the 30%. This is the kind of information that allows our decision makers and our residents and communities to understand what the impact is and how to make the right decisions going forward.
And I think that's really helpful. That's a good overview of what we could be doing right now. For us folks who have been in local government, for the elected officials, this might be something that's easily digestible. But for voters or residents, it might not be. And so I imagine, I don't even have to imagine, even from my own experience with the clients that I serve, many of them want to communicate to their residents. They want to get the word out. And so what can and can't cities do? What draws the line between advocacy versus just informational outreach?
Well, there's a very significant line between advocacy and communication. Advocacy is when you're saying that you're in support of something or you're against something. You're actually advancing a position on it. And that has long been something that is not something that you can do with public resources. There is a statute on point. It's section 106.113 Florida statutes, and it does provide that public resources can be used in some ways to engage in the dissemination of factual information to the public. And some of the examples of the things that you can do under the statute include prepare information about the impact, certainly. Include that information in an item that is on the agenda of your regular commission meeting. It goes into the agenda backup. You discuss it on the dais. You have presentations. You could take that information, you could include it in your newsletter that you send out to the community that talks about all of the things that affect your community. This is something affecting your community. You could touch on it there as well. You can also communicate through other kinds of ongoing communication activities. Some cities have routine emails that they send out. Others have a social media presence where they're pushing out information generally about their community. Any of these places that are pre-existing channels are places where factual information can be conveyed. One thing to be careful of on social media, sometimes because communities that have significant tourism, as many of our Florida communities do, are looking to market themselves to a broader audience and bring in tourism, they may actually be investing resources in boosting those social media posts. So that's something that may be not necessarily the best thing to do when it comes to this kind of communication. But just placing it in those social media environments is also something that's allowed.
Okay. I think that will provide a lot of clarity for some folks at this moment. In addition to what we might see through newsletters or social media, I know there are probably some elected officials or local government officials that are being asked to speak publicly, right? Whether it's making a comment with the news or being quoted in the paper. What would you say is the fine line there? What should and should not be done?
Well, the limits don't actually apply to the elected officials in the sense that they have First Amendment rights.
Right.
And so regardless of whatever statutes and rules exist about what cities can do, those are not going to prevent individuals from exercising their First Amendment rights, whether it be to convey factual information or if it's even to advocate for or against the outcome of this amendment or anything else. And so, they have their voice speaking as an individual. The caution would be not to stray into speaking on behalf of the entity. It needs to be an individual expression of an opinion.
So that's a really good distinction that you were able to draw between what elected officials can do versus what cities can do. So pivoting back to our cities, what should cities be doing at this moment, or what can they do rather at this moment as it relates to budgetary concerns?
Well, I think there's a lot that they can do this year, and it's important to understand that while we're waiting to see if the voters are going to approve this, and if they do, it won't become effective until the 2027-2028 budget year, the decisions made this year are going to lay the groundwork for dealing with what may come next year. So what do I mean by that? Well, if your government is wanting to look for new sources of revenue, sometimes there's substantial lead time involved in pursuing that. So for example, if you decide that it's an appropriate thing to create a new special assessment or a new special taxing district, the way the laws and procedures around that work, you have to have someone prepare an analysis to show the benefit to property and create the methodology that would be legally defensible, you have to take official actions before the end of 2026 to be eligible to have all that lined up to place on the tax bills in August so that it gets implemented for the 2027-2028 year. Other kinds of revenues similarly can have lead times associated with them. Our cities have building permit fees, and there's a statutory construct for how you go about preparing that. You need studies, you need work to be ready to adjust those and make sure that you've gone through and checked off all the boxes for the analysis, the notices, the hearings, if you're going to be adjusting that. Impact fees, similarly, you may need consultant reports that can lead you to be able to update those revenues. And the thing to note is that a lot of these fees and charges, cities and counties may have made a policy-based or political choice, which is entirely within their discretion, to undercharge. Like the data may show that they could legally go up to a certain amount, and they may, for other reasons, charge less than that. If this revenue environment is going to become so much more challenging, I think every governing body is going to need to stop and think about, can we still afford to do that in our community?
Right.
At least certainly the ones that are most heavily impacted by tax reform may really have to think about a hard answer to that question. And then other things they can do is sometimes you might be looking at a multi-year contract that you have to make the decision this year. Maybe it's your collective bargaining agreement with your union. Maybe it's a multi-year contract for the sheriff to provide your police services. There are many examples. You should be thinking this year about, if tax reform happens, can I pay for that next year? What are my strategies for how to deal with that? Do I need to negotiate a better deal, try to limit the cost? Are there innovative ways that I can cover the cost? So those are some of the things that can be on the immediate to-do list so that you have laid the groundwork for coping next year in the event that this passes.
Right, which is, I think it's important, right? Whether you're a proponent or opponent of this, there is something that local governments can do in the meantime to start preparing if things were to continue. So thanks so much, Susan. I appreciate you taking out the time to speak with us. I think the audience is going to benefit so great from this conversation. And so thank you again for being here on The Intersection.
Thank you.
Thank you so much, Susan, for joining us. Thank you as well, Jamie. As we discussed today, this proposal is about much more than tax relief. It raises important questions regarding local government finance, service delivery, constitutional law, and the future relationship between state and local government authority. As this proposal continues through the constitutional amendment process, local officials will need to carefully evaluate both its intended benefits and its potential consequences. Consider whether to join in any lawsuit challenging the ballot language, and begin taking any steps that might be necessary now to lay the groundwork for what may be coming next year. We will continue to monitor developments and provide updates as they occur. Thank you for joining us for this episode of The Intersection. I am Chanae Wood. I'll see you next time.